Hi, today we're going to talk about patents. What is a patent? The United States Patent and Trademark Office defines a patent as an intellectual property right granted by the government of the United States of America to an inventor to exclude others from making, using, offering for sale, or selling the invention throughout the United States or importing the invention into the United States for a limited time in exchange for public disclosure of the invention when the patent is granted. The right conferred by the patent is, in the language of the statute and of the grant itself, the right to exclude others from making, using, offering for sale, or selling the invention in the United States or importing the invention into the United States. What is granted is not the right to make, use, offer for sale, sell, or import, but the right to exclude others from making, using, offering for sale, selling, or importing the invention. Once a patent is issued, the patentee must enforce the patent without the aid of the USPTO. Some facts about patents. Most patents are good for 20 years from the date of the application filing. The U.S. patents are good only in the United States, U.S. possessions, and territories, and international patents are needed if you need a patent outside of the U.S. There are three types of patents. There are utility patents, design patents, and plant patents. Utility patents may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. Utility patents are probably the most popular type of patent and ones that we're most familiar with. Design patents are filed to protect the unique appearance of manufactured items such as furniture. This patent does not protect the function of the manufactured item, just the appearance. Some examples of design patents include jewelry boxes, furniture, car wheels, kitchen sinks, designs of watches, containers, and clothing. Some elements to design patent include the preamble, stating the name of the applicant, the title of the design, and a brief description of the nature and intended use of the article in which the design is embodied, a description of the figures of the drawing, a feature description, a single claim, drawings or photographs of the element, and an executed oath or declaration. An example of this would be, I, John Doe, have invented a new design for a jewelry cabinet, as set forth in the following specification. The claimed jewelry cabinet is used to store jewelry and can sit on a bureau. The main difference between a utility patent and a design patent is that a utility patent protects the way something works. A design patent protects the appearance of something. The third type of patent is the plant patent. A plant patent is granted by the government to an inventor who has invented or discovered and asexually reproduced a distinct and new variety of plant, other than a tuber propagated plant or a plant found in an uncultivated state. The grant, which lasts for 20 years from the date of the filing of the application, protects the inventor's right to exclude others from asexually reproducing, selling, or using the plant so reproduced. What does a plant patent cover? Plant patent covers a living plant organism which expresses a set of characteristics determined by its single, genetic makeup or genotype, which can be duplicated through asexual reproduction, but which cannot otherwise be made or manufactured. Sports, mutants, hybrids, and transformed plants are comprehended. Sports or mutants may be spontaneous or induced. Hybrids may be natural, from a planned breeding program, or somatic in source. While natural plant mutants might have naturally occurred, they must have been discovered in a cultivated area. Algae and macrofungi are regarded as plants, but bacteria are not. A fun fact about plant patents: in 1948, about half the plant patents that were filed were for different types of roses. There were about 750 plant patents filed in 1948. Some examples of plant patents include the thornless long blackberry plant, seedless grapes, and seedless watermelons. What others can you think of? Possibly seedless oranges? The following slides will list the patent filing process that is directly laid out by the United States Patent and Trademark Office. This will get us through our design and utility patent process. The first step has you check to see if your invention has already been patented. Search the patent full text and full page image database and the USPTO database. If your idea has already been patented, that's the end of your process. Time to go back to the drawing board. If it is not patented, continue step 2. To search through these steps, you can brainstorm keywords related to the purpose, use, and composition of the invention. Look up words in the index. Verify the relevancy of the class and subclass. Read the classification definitions to verify the scope and subclasses. Search issued patents in published application databases by current U.S. classification, and access full-text patents in published applications. Review claims and specifications and drawings of documents retrieved for relevancy to see if any match what you're wanting to patent yourself, and check all references and note the USCL and field of search areas for additional class subclasses to search to make sure there's nothing you missed. Step 2, what type of application are you going to file? A design patent, plant patent, or utility patent? The next step will be determining your filing strategy. Do you need to file globally? Will you need international protection? Are you just going to file in the U.S.? If so, continue on to the next step. If you do need to file internationally, the USPTO lists ways to file for an international patent. There's the Patent Cooperation Treaty, the Hague Agreement concerning the international registration of industrial designs, the Patent Prosecution Highway, Common Application Format, the Common Citation Document, New Route, Triway, and Share, all to file international patents depending on your needs. Step 4 in the patent filing process is which type of utility patent application to file. Will you need provisional or non-provisional? Why would you file a provisional patent application? One, it's faster and less expensive than filing the non-provisional patent application. It gives you up to 12 months to file the non-provisional patent application, and you can start using it immediately so you can start producing your goods or selling them. What is a provisional patent application? Well, the USPTO defines a provisional patent application as a provisional application for patent establishes your priority filing date with the U.S. Patent and Trademark Office and lets you immediately start labeling your invention patent pending. What is a non-provisional patent application? The USPTO defines a non-provisional patent application as being examined by a patent examiner and may be issued as a patent if all the requirements for patentability are met. After that, you go on to step 5. You'll consider the expedited examination. These 4 list all the examinations for this step. Step 6, who should file? You can file yourself or use a registered attorney or agent. The USPTO also lists attorneys in your area, some who even do the work pro bono. The next step will be to prepare for electronic filing. Determine your application and processing fees by following the link here, and then you can apply for a customer number and digital certificate. Your customer number allows you to easily correlate all your filings and correspondent with a single mailing address, eliminating typographical errors or variations in addresses that can make it difficult to correspond with USPTO. This customer number will also ensure that only you can access your patent application information. Electronic filing can also reduce your patent application fees. The next step is apply for patent using electronic filing system as a registered e-filer. As I mentioned before, this can help reduce some of your fees. The EFS Web is the United States Patent and Trademark Office's patent application and document submission solution. Anyone with a web-enabled computer can file patent applications and documents without downloading special software or changing document preparation tools and processes. Step 9, the USPTO examines your application. While they're doing this, you can go and check your application status. If it's allowed, you can go on to the penultimate step. If not, you'll continue on to step 10. In step 10, you'll file reply request for reconsideration and appeals as necessary to try and get your patent to go through. In step 11, if objections and rejection of the examiner are overcome, the USPTO sends notice of allowance and fees due. These fees are based on the size of your business, small, medium, and large, and are the fees that you will pay to have your patent filed. Step 12, the penultimate step that you could have skipped to if your patent went through the first time, is the USPTO grants patents. Again, after paying your fees for this, your patent will go through. The next step will be your maintenance fees. These will be due at 3.5, 7.5, and 11.5 years after your patent is granted. This lists the fees, again, by the size of your organization, and shows you what you need to pay on these milestones. So in conclusion on patents, patents are issued by the United States Patent and Trademark Office. They're part of the Department of Commerce. Patents are good. Most patents are good for 20 years. And there are three main types of patents: design patents, utility patents, and plant patents. Next, finally, we have a chart here that outlines this process. We went through kind of the Word document process, laid out step 1, step 2. This chart lines out the same thing, just in a flow chart. This comes directly from the USPTO website. The references I use are from the United States Patent and Trademark Office. Their website is www.uspto.gov/patents. Thank you.